Good morning to all of you. Welcome to Legal Matters by Sai Babu Shankar. Of late, Supreme Court is using beautiful phrases. In my previous video, Supreme Court said that legal aid to poor should not be poor legal aid. Likewise, today we are going to discuss a case of maintenance. Section 125 CRPC, Section 144 of the Bharatiya Nagarik Suraksha Sanhita, in which the court, this is of course Madhya Pradesh High Court, they stated that this section, that is section 125 CRPC, should not create army of idle persons, army of idle people waiting for maintenance. That means people should not only depend on the maintenance. That's why in the beginning of 165, 125 CRPC will be telling you, unable to maintain himself, herself or itself. Unable to maintain is an important word. In the case of XX versus Y and others, Criminal Revision number 301 by 2020, Honorable Justice Prem Narayan Singh on 15th October 2024 held that, of course while modifying the maintenance order, held that this provision should not create army of idle people waiting solely for the maintenance for their sustenance. As usual, the case brief facts of the course they care like this. Actually, the family court indoor, they have given order that the husband X has to maintain his wife by paying monthly allowance of 25,000 to her and 15,000 to the daughter. In total, he has to pay 40,000. Agreed by this, he has gone for revision before the Honorable High Court of Madhya Pradesh under Section 19 of the Family Courts Act, because it is burdensome for him. In the counter, he has attested the press clippings, newspaper reports that wife Y is a model, she is an artist, she acted in a couple of films, she acted in serials, she can maintain herself. For the cause of maintenance, he has taken loan from the bank and he is paying maintenance to her, which is becoming very, very difficult to read because he has to maintain his brother and actually he diagnosed with something. He is a father, ailing father. He is facing much difficulty. He also added that at the time of delivery of the baby, his wife's parents did not spend. He has spent about 50,000 for the delivery. Right? And of course, the defense is that he is depending only on the press cuttings which are declared as hearsay evidence by every court. There is no strict proof to say that she acted in films. Of course she acted, but how much remuneration they will get? And that too, acting in films or the fashion model, all these things, they are only temporary pages. They can't be permanent. It's not a government job. But overall, it is learned that she is able to maintain herself to some extent. Therefore, there is a modification. Before that, wife says he is earning 1.26 lakhs per month as a manager of HDFC bank. But how many cuttings will be there? That also you have to understand. So taking into consideration of all these aspects, Honorable High Court reduced the maintenance from 25,000 to 20,000 to her. Of course, the standard for the daughter is 15,000 only. So with this small modification, Mr. Amit Goyal, the husband, right, he is to some extent satisfied. Okay, read the case law and enrich your legal knowledge. Thank you.